Good afternoon, guys. I'm attorney Philip Adams with the law offices of Philip Adams here in Shreveport, Louisiana. And I want to talk to you specifically about a Louisiana criminal defense topic involving free speech rights and being charged with a violation of Louisiana Revised Statutes 14:91.5, specifically unlawful use of a social networking website. I believe that this law is unconstitutional on its face, meaning the law is unconstitutional in its entirety because it violates the free speech clause of the Louisiana Constitution, specifically Article 1, Section 3, and the free speech clause of the U.S. Constitution, specifically within the First Amendment. Now, LARS 14:91.5 is a law that basically criminalizes the use of a social networking website by sex offenders. And you may ask yourself, well, who cares? I mean, no one cares about sex offenders. Why would we care about whether or not they're prohibited from having access to social media websites? Isn't it a good thing that we prohibit them from having access to social media? Well, there are important things to think about when examining the constitutionality of this statute. So let's go ahead and just look at the law. So let me read relevant portions of the law. So the following shall constitute unlawful use of a social networking website. Subsection 1, the intentional use of a social networking website by a person who is required to register as a sex offender and who was convicted of, and it lists various crimes, and so on. So basically, if you look at LARS 14:91.5, it does not make any exceptions whatsoever for using a social media website to seek employment, to look at ads for potential products that one might want to buy. Maybe you wanted to buy a tractor or a lawnmower or something. Nope, you can't use a social media website to look at for sale stuff or garage sale stuff, anything like that. If you're seeking a job, can't use a social media website like Facebook for that. That's unlawful too under this law. So basically, the way that the law is construed is it's so broad and so vast that it completely impinges on potential protected speech, or which would fall under the right to have access to public forums and information. So if an individual wanted to protest something or petition for grievance or use Facebook to post about some wrongdoing, that sex offender would not be allowed to even do that. So the law is so broad that it undoubtedly criminalizes a substantial amount of protected speech and conduct under the U.S. Constitution and the Louisiana Constitution. Now, I don't want to be misconstrued. The sexual abuse of a child is absolutely repugnant and abhorrent. I have a child myself. Decent people do not engage in conduct like that. A legislature can pass laws to protect children and other victims of sexual assault from abuse. There's no doubt about that. However, the assertion of a valid governmental interest cannot in every context be used to insulate a law from constitutional scrutiny. So if a law, while passed with good intent, as I believe this law was passed, happens to criminalize protected speech, that's problematic. It means the law is unconstitutional. The framers of this law, the Louisiana legislature, likely thought that in passing this law, we can, by not having sex offenders have access to any type of social media, we can minimize the probability, the likelihood of sex offenders using these social media platforms like Facebook or Instagram or what have you to prey on young children. And that's a valid thought, absolutely. These mediums of communication are routinely used to abuse and prey on young children. There is no doubt about that. However, the law isn't written and narrowly tailored in a manner that only attempts to criminalize that type of conduct. In other words, it doesn't say it is unlawful to use a social media website to groom children, yada, yada, yada. It doesn't say that. It simply makes it unlawful to use a social media website, period, if you're a registered sex offender who falls under one of the types of offenses listed within that statute. That is too broad. It goes too far. Sex offenders, even if they engage in reprehensible conduct, still have First Amendment rights. They still have the right to petition their government for grievances, for redress of their grievances. They still have the right to seek employment and inquire about employment through using social media websites. They have the right to look at ads on social media websites. They still retain these First Amendment rights, despite the reprehensible conduct that they may have engaged in. So this law is problematic because it has one overbroad stroke that attempts to prevent access and use to what for most people would be a principal source for knowing current events and exploring the vast realms of human thought and knowledge. Now, fortunately, even though LARS 14:91.5 is still in effect, the United States Supreme Court has actually addressed the crux of the issue that is presented in this discussion through a case called Packingham versus North Carolina. It's a similar case, and it's a 2017 U.S. Supreme Court case in which the U.S. Supreme Court unanimously reversed in an 8-0 decision based on First Amendment grounds a conviction of a registered sex offender in North Carolina for a North Carolina law that made it a felony for a registered sex offender to access a commercial social networking website in which the sex offender knew that the site permitted minor children to become members or to create or maintain personal web pages. The petitioner in this case in Packingham was convicted for having used Facebook with no allegation, however, that he used the website in any manner to facilitate the sexual abuse of any child or sexual abuse of anybody for that matter, child or adult. And the Louisiana law that I discussed, 14:91.5, and the U.S. Supreme Court case of Packingham are similar in so many ways that I believe that the same rationale that was applied in Packingham could be used to strike down the Louisiana law on constitutional grounds. So, if you know somebody who has been charged with a violation of LARS 14:91.5, it is important to understand the constitutional dimensions of this law and contact a knowledgeable and competent defense attorney who can explore ways in which one can fight back against an unjust application of this law. Take care.